Hello everyone, my name is Aarti and you're watching HW News. After 10 days of hearing and reserving the judgment on September 22nd, the Supreme Court today gave out a split verdict in the Hijab Ban case. The bench of Justices Hemant Gupta and Sudhanshu Dhulia had a divergent opinion on the case. While Justice Hemant Gupta upheld the ban on hijab, Justice Sudhanshu Dhulia set aside the Karnataka High Court order upholding the Hijab Ban. The matter has now been placed before the Chief Justice of India. He will decide whether it should go to a 3-judge constitution bench or not. What exactly has to be done in the matter, the Chief Justice of India will decide on it. So let us talk about what both the judges today said while pronouncing the verdict. But before that, if you're watching this video on YouTube, please make sure you subscribe to our channel, you like this video and you comment below it, and press the bell icon so that you never miss any video update from our side. If you are watching this on Facebook, then please follow our page. Now you can also access our article, videos and live TV on our app. If you haven't already, download HW News Network app on your Google Play Store now. Let's talk about what Justice Hemant Gupta said. A batch of 23 petitions was filed in this connection, some of which were writ petitions which were placed directly before the Supreme Court, while others were appeals by special leave preferred against the judgment of the Karnataka High Court upholding the order. Justice Hemant Gupta dismissed all the 26 petitions before the top court. He said, and I quote, "There is a divergence of opinion. In my order, I have framed 11 questions. First is whether appeal should be referred to Constitution bench, whether college management can take a call on uniform of students, and if wearing of hijab and restricting it is a violative of Article 25, whether right under Article 19 and Article 25 is mutually exclusive, whether government order infringes upon the fundamental right, can student exert her fundamental right, is wearing right a part of essential religious practice under Islam, whether government order serves purpose of access of education. The answer, according to me, is against the appellant." That is what Justice Hemant Gupta said. Now let us talk about what Justice Dhulia said. Justice Sudhanshu Dhulia, while pronouncing the verdict, expressed a completely different view to that of Justice Hemant Gupta. He predicated his decision on the primacy of choice. He said that the legality of the order had to be tested on the touchstone of Articles 19(1)(a) and 25(1). He also noted that the High Court had erred by examining the essentiality of wearing the hijab. He said that the doctrine of essential religious practice did not have to be invoked in this particular case. He said, and I quote, "The main thrust of my judgment is that this entire concept of essential religious practice, in my opinion, was not essential for the disposal of this dispute. The High Court took wrong path there. This was simply a question of Article 19(1)(a), its applicability, and Article 25(1) primarily, and it's ultimately a matter of choice, nothing more, nothing less." He explained that the factor that weighed heavily with him while reaching this conclusion was the importance of the education of a girl child and the many difficulties faced by her, especially in rural and semi-urban areas. He acknowledged that girls had to carry the burden of unpaid care and domestic work alongside their education. Justice Dhulia wondered whether the life of a girl child would be better by imposing an additional restriction on her. He said, and I quote, "But the thing that was most important in my mind while deciding this case was the education of a girl child. It's common knowledge that already a girl child, primarily in rural areas and semi-urban areas, has to face a lot of difficulties. She has to help her mother in daily chores, in cleaning and washing before she goes to school. There are other difficulties as well. What I asked is, are we making her life any better?" Therefore, disagreeing with his colleague on the bench, Justice Dhulia said, "I have allowed all the appeals and set aside the order of the Karnataka High Court. I have quashed the government order of February 5, 2022 and given the directions for the removal of restrictions." So well, that is what Justice Dhulia said. That means that the matter of hijab ban remains undecided. In the case of split verdicts such as this, the current hijab ban upheld by the Karnataka High Court will continue, and what will happen next in the matter, the Chief Justice of India will make a decision. Do let us know what you think about this in the comment box below. For more news and updates, you can log on to www.hwnews.in.
Now be the first to know about the latest updates on our new news app. Go on your Android or iOS, search for HW News Network. Download our app, choose the language you prefer to get updates in, and be up to date with the latest news.